All right, good evening, folks. Welcome to Monday Night Law here with Kirk's Law Corner. How's everybody doing out there? Whoop, forgot to unmute myself on Telegram. All right, good evening, everybody. Well, the rest of you on Telegram. Forgot to unmute over there. Sorry about that. Oh, make sure we got good audio here tonight. Good to see you over there. Is it Tigger or Tiger? On Telegram. Eager Beaver, what's happening, brother? On X. So it's working on X, all right. I am curious what happened there the other day. Did not go out on YouTube when we were talking about the Texas border deal there and military accountability project. I don't know what I ended up just uploading it over there to YouTube to get it out there on YouTube. Sweet, good audio on X. Okay, so it is Tiger. Corruption Detector, Diesel D's, good to see you, brothers. So, gonna be a little bit of a showdown down there on the border there, Texas border, where Supreme Court ruled on that and said, "Oh well, it can't. Got to take down the wire." So I haven't seen anything where they said they were going to do that. So my guess is nope. So we'll see what happens there. And then, of course, now we got the truckers convoy. It's kind of crazy. Remember, they already did this once before, except for it was out on when they went to D.C. But there's a mixed word out there. Right, Diesel D says was just going to say that there's people saying no, don't go, blah 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 blah. The reality is, folks, all political power is inherent in the people. The militia is composed of the body of the people itself. That's where the source of militia comes from, is the people, and the military is subordinate to the civil power. So maxim of laws, what a man does in his defense is to be considered legal. And as I've already covered, and we'll get back into Blackstone's Commentaries on the Law of England here in a little bit. Tonight we'll be getting into that property, the absolute right of property. But if you remember, the first absolute right is personal security. Now let's put this in perspective. Do I have the right to defend my life? The answer is yes. Do I have the right to defend my liberty? The answer is yes. Do I have the right to defend my property? The answer is yes. So, if I have the right, let's say, to defend my home, anybody who comes on my land, I have every right to, up to and including taking their life, with just cause. They failure to depart, that's grounds. There's whether people like that or not is irrelevant. It's a fact of law. The right of personal security is an absolute right, unalterable. At no time does any man or set of men have the authority to alter that fundamental principle of law. At the root of all law is an absolute right of self-defense. So on a grander scale, we have the right to defend our nation. Because we have the right to defend our home. We have the right to defend the territory. Some people will say state, but state is a little bit different. It's a state of being. But the territory, there we have metes and bounds, which is still property, land. And it's a simple answer to the question here. Are we being invaded or not? Is this a foreign invasion or not? If it is a foreign invasion, the first duty and who it belongs to is the people, the militia, which is every able-bodied male between the age of 17 to 64, is automatically duty-bound to defend. Comes back down to that law of nature, the right of self-defense. And again, the military is subordinate to the civil power. Again, we have to, like our founders wrote in some of the early constitutions, was we need to have a frequent reoccurrence to fundamental principles. Well, we haven't even had a reoccurrence to fundamental principles in a very long time. I would say that as a worldwide thing, let alone just America. And they sure heck haven't been teaching this stuff in school. And like I brought up before, is that, there's a video out there of the General Lee. There was a little over a year ago when they took down the statute. And they found that time capsule box thing down there. And they were opening it up and going through stuff. And they found 4th grade curriculum teaching 4th graders the law. Okay. Where are we at on that today? This should answer your question of why we're so dumbed down. Is because they've taken it out of our school curriculum. On purpose. So that they could purposely dumb down society and they can get away with things because nobody no longer knows what the law really is. Which brings me to why I'm here. Why I feel that God has compelled me to do this, which again, I had no idea that when I made that vow to God sitting in a jail cell in 1995 to start studying the law so that I wouldn't get screwed like that again, would turn into this. Me sitting here on a Monday night sharing my knowledge of what I've learned from reading. I've had a recent comment out there, which is pretty common. Well, where did you learn all this stuff? What school did you go to? It's called a book. These things, like here's one of my good ones here. This is called Bills, Quills, and Stills: An Annotated Illustration and Illuminated History of the Bill of Rights. It's all just on the Bill of Rights. Okay, just this book. Here's a very, 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 very good one. Lex Parliamentary Americana: Elements of the Law. Practice of Legislative Assemblies of the United States of America. This one's full of law. Okay. And here's another really, really good one. Probably one of the better ones out there. But, the Bible. This one here is the Founder's Bible. Okay. And it's loaded with all these inserts in here where our founders pulled from the Bible about real law. Not only that, in part, this is where maxims of law come from. Right here. God's law. Fundamental principles like those without sin may cast the first stone. And we're going to be reading from a really good source of law and history of law again tonight. Blackstone's Commentaries on the Law of England. If it's good enough for the Supreme Court of the United States to cite as a foundation, as a source of law, don't you think we ought to be reading that? I do. Like I said before, I've had that for quite some time. I just at the time thought, well, it's Blackstone's. It's part of English, right? Which also led me to think about Black's Law Dictionary. It's like, wait a minute, why are we citing from Blackstone, Black's Law Dictionary, if we're in America? So, this knowledge is power, right? We have to study, because we're not going to gain this knowledge from going to school. And here's a fundamental principle. Since when does anybody ever have to go to school to learn anything? I mean, seriously, we can't learn this stuff on our own anymore? And in today's day and age, with the information highway out here, there's no reason why any man or woman can't do a quick search, whatever your search engine is, for just about any subject you want to learn. The information is just at our fingertips. It's at the point now it's on our frickin' phones. We call them smartphones, but sometimes they're not as smart as I think. Or smart as I wish they were. So, why can't we study on our own, on any subject? You don't have to go to school. Now, granted, there might be some things like, a surgeon, right? But even a surgeon doesn't have any experience until he actually does it. So you might want to learn some anatomy and that kind of stuff. Great, yeah, I get that. But how does a surgeon gain his experience? By actually doing it. He doesn't know how to do surgery until he actually does it. So there are some things out there that I may say that you might want to go through some special training for. But what happens if you decide to, watch some videos? And learn from a surgeon who has experience and watch him do it or whatever. Are you saying that a man or woman can't learn by watching somebody else do it? Who knows? There may come a time that there's somebody out there that watched and learned and has a basic idea and may save your life out there in the woods or the forest or whatever, out on the side of the road. Well, they're not licensed from the pharmaceutical industry now to be a surgeon. Whoopee. Does it save the life or not? So, there's a question out on YouTube. Does that right still stand for a felon? Absolutely. There's no such thing as a felon. See, there's more shit made up. Because it's either a capital offense, capital crime, which means your punishment is death, or infamous crimes. So what we would consider felony should be called a capital crime, and they would be sentenced to death. Now, here might be a shocker to some people out there, but even in the Idaho Criminal Practice Act of 1864, it specifically states in there that once you're done with your time and you get out, you get all of your rights back. Why? Because these fundamental rights, these absolute rights, come from nature. They don't come from man. They don't come from government. These are absolute rights. Now, like even Blackstone talks about, clearly you can't have arms. Or no, maybe it wasn't Blackstone's. Who was it? Maybe it was the New York State Rifle Pistol Association versus Bruin. Clearly you can't exercise your right to keep and bear arms while you're incarcerated. I mean, that's like a no-brainer, right? But if we all have the fundamental, absolute right of self-defense, how can you deprive a man of his right to keep and bear arms, to defend himself, and then, more importantly, to defend the nation? It'd be completely illogical. And I know that there's things out there that like that used to be on the books there, that when people got out of prison, whatever, they were given a horse, a rifle, and like $100 worth of gold coins, right? So they could get themselves kind of set up and going again. How do we look at that and go, well, wait a minute? Thing is there cannot be, Miranda versus Arizona, there shall be no rulemaking or legislation that would abrogate a right. That's because it's an absolute right. It's no longer an absolute right if man or set of men can deprive that right. Like just absolutely take it away forever. Now, somebody commits murder. They should be executed. We don't have to worry about that. Plain and simple. Done deal. So yes, absolute rights are always absolute. Now, I've seen Leslie over here reading Federalist Papers. Thank you for reading. Good to see you, Leslie. Federalist Papers 69 and 84 refer to Blackstone Commentaries. Yeah. Yeah, Greg out here on Facebook, I don't know. I think we just need what I think's coming anyways, is a worldwide revolution, and the power just needs to be in the people's hands, and the public servants need to be servants. We need to get rid of this ideology of rulers, kings and queens, and all this stuff, which, I've explained this over the years now, that this is what's coming, what's been happening. And even Trump said many, many, many years ago now that we're going to have a completely different kind of government than we've ever seen. And I think he's more specifically talking to people who are alive today. Maybe not somebody like me who's done a lot of research and dove into the different forms of governments and understanding the different hierarchy within that system, and the form of government itself. Kings, prince, having a king and a prince, and having a parliament. Why our founders created our one-of-a-kind form of government, which took some time. Over time, developed this form of government that was basically declared and established starting in 1776 with the Virginia Constitution, June 29th, 1776, with our very distinct three branches of government, the separation of powers doctrine. All of that came about in 1776 in that Constitution. That is the first real Republican form of government constitution that was created for the new nation called America. Remember, we were still a British colonies up until the Lee's Resolution, June 6, 1775, or 1776. That was June 6, 1776. That's the document that separated us from Great Britain, not the Declaration of Independence. Then you have the Virginia Declaration of Rights that declares Christianity as our ideology. Then the Virginia Constitution. Then you have the Declaration of Independence. And like I've said many times out there, folks, read all four of them documents together and have a better understanding. And when you read the Virginia Constitution, you're going to see most of what's in the Declaration of Independence is in that Constitution. When we read the Declaration of Independence, what does it read in there? It says that we must declare the causes for the separation. That was what that Declaration of Independence was declaring the causes for the separation. The Lee's resolution was the separation. So it enumerated clear acts of tyranny by the king. Those are the reasons why. And so what I call that is an enumerated declared acts of tyranny. So if we're experiencing any of those kinds of characteristics and conduct today, then if it was tyranny in 1776, it most certainly is tyranny today in 2024. Just as it was with the Magna Carta of 1215, just as it was in the English Bill of Rights of 1689. Many people are not aware of history, but this has happened before, many times throughout history. Not just even 1215, okay? It's happened over and over and over again, all throughout history. Hi, CC. Good to see you. From Alaska, it's 50 below zero. Oh. I know I was talking to Destry the other night. We did Friday night, talking about government de jure and the assembly stuff. And he sent me a picture. It was minus 42 there, and I sent him a picture. It was 42 degrees here. That's 84 degrees difference. But that's a little chilly up there. Stay warm. Yeah. And actually, Ram Red Bud put out there his hyphen story. It's actually Tory with no S. Tory. What we think is story is actually Tory. And that's where his Tory comes from. History. His Tory. Just a little fun fact for you on the English language. Right. Oh, what else we got here? Brother Art, good to see you. So, anyways, back to the Texas border thing. You know, we have this absolute right to defend this nation called America. America is the nation. America is not a country. It is a nation. Okay? And in the law of nations, and I've showed this before, a nation is made up of all of the countries. So what we refer to as a nation state is a state of being, grateful to Almighty God for the blessings of liberty, right? That's our state of being, is a state of being as a government, essentially, or state of society, state of being. But we always have this fundamental law. That's the key to all this is, you know, what we're discussing here tonight, again, when I get into Blackstone's, is fundamental law. It's so fundamental. This stuff is supposed to be self-evident. This is the ignorance of the law is no excuse. Rights as the law. We're all supposed to know that, because those would be rights that we have in common. Sometimes referred to as common law, but would be common rights. And like I've exposed there from Blackstone's Commentaries on the Law of England before, is the origin of the so-called common law was from the Saxons, which were the Christian Protestants, which were maxims of law and customs. Maxims of law? Huh. That come from over there in the Bible there. So I think that's what we need to do, is we need to get back to these fundamental principles, have a frequent reoccurrence to fundamental principles. We need to learn the fundamental law itself. And then we will know anything that comes in conflict with that would be void for any effect, because if it's no longer fundamental, if man can mess with it, it's no longer absolute if mankind can mess with it. But some people get away with this because of our lack of knowledge. So again, it would behoove us to learn some fundamental principles, fundamental law. So, I know that there's a talk about that it's a setup like another January 6th thing. Well, I guess that'll all be sorted out in the end, won't it? But it's the intent. It's right on their paperwork, their flyer they put out there, that this is a peaceably assembling. But again, we have the right to do that. We have the right to defend. Not just peaceably assemble, but the right to defend. We have the right to defend this nation from foreign invasion. And that right is inherent in the people first. Plain and simple. It's only when the people can't take care of it that we call in the military. So there's those fun facts for you. I know, right, Mark? Most in government have no idea what law is. I mean, what is law? Well, first of all, let's talk about the word itself, law. Not as in LAW, law of the land, law of the air, and law of the water. Okay? Comes from the French word droit, meaning right or law. So this is why I talk about rights are actually the law. And it's even in Bouvet's Law Dictionary, when you look up the word right. Well, sometimes it means law. Well, I know that the word law can be used to define many different things. But let's look at the fundamental part. The origin of the word itself. What does it mean when the word was created? Right and law are synonymous. So if it's not a right, then it's not law. Would have to include a right, because if they're synonymous, they mean the same thing. It would have to be interchangeable. So like, for example, a statutory law. What do you mean? How's that law? Where's the right? No, it's just called a statute. That's it. It's an enactment. It's not law. Yeah, you bet, Greg. Absolutely, CC. Are not rights afforded to everyone, not just Americans? Yeah, this is supposed to be absolute from the laws of nature. This all should be like common sense. But you have, what we call third world countries. They don't have any education at all, really. And yeah, we don't have, even here in America, our education system is so rotten to the core, it's not even funny. So again, we need to have this frequent reoccurrence to fundamental principles, and starting with absolute rights. I mean, we got to start somewhere. I mean, let's think logically here for a minute. If we're going to talk about what our rights are and start at the beginning of even discussing law at all as a whole, where should we start? What's the guiding principles? I mean, we have to lay down some principles here, just like in any board game, Monopoly, chess, right? There's rules for the game. Those are the principles of the game. And like chess, I like to use chess specifically because there's absolutely set fundamental principles to that game. And you cannot step outside of those fundamental principles. Like castling, how a bishop moves, how a knight moves, how a pawn moves. And here's another fun one, fundamental principle is en passant. When a pawn goes past another pawn, you can take it. When they are challenged and they don't take the pawn and try to move past you, it's called en passant. Okay, there's a principle in the game of chess. And then the other one, castling, depending on which side, if you're castling the king side or the queen side, how many spaces the king moves and how many spaces the castle moves, the rook. So we have to know these fundamental principles first before we can even play the game of chess. So just like life, we have to understand these fundamental principles. And that's why it's sometimes referred to as the laws of nature, because basically it comes from God, right? The Creator. Whether you believe that or not is irrelevant. Right? You could be an atheist, but in order to be an atheist, say, well, I don't believe in God. Well, to be an atheist, you still would have to believe in God, because you can't believe in something that doesn't exist. Or you can't believe that something doesn't exist if it doesn't exist. So it's an oxymoron. Well, I'm an atheist. Well, yeah, that's the belief that something doesn't exist, but then you're admitting that something doesn't exist. Kind of an oxymoron. So, absolutely, Diesel D's. The deep state has successfully destroyed the American family unit. That's part of Rules for Radicals by Saul Alinsky. Destroy the family unit. And you can thank your local CPS or DSS or whatever it's called in your area there, social services, and schools, our education system. They've taken over the money, they've taken over the government, taken over the medical field. But see, it's not medicine, is it? Medicine comes from nature. Pharmaceutical drugs are manufactured, and they're all synthetic. And they cannot copyright nature. Huh. Imagine that. So as far as I'm aware, there really isn't any pharmaceutical drug that cures anything. Ask yourselves that question. What is the cure? Ask your doctor if any of is on medication prescribed by a pharmaceutical drug pharmacy, ask them, is this going to cure me? So what's the cure for this? I mean, we're in 2024, and with the technology that we have now today, what's the cure for my ailments? This dis-ease. You'll end up with deer in the headlights. Because they know nothing about real medicine. They only know what they're pushed, which is by drug dealers. Those are drugs, people. Anything that comes from nature is natural. Medicine. Food that we can consume from nature. But if it's a pharmaceutical drug, what's the cure? Why do you think holistic and naturopath doctors are, they call them doctors, but medicine men, medicine women, for a while they're seriously being attacked. I know that it's been a little bit since some of our holistic or naturopaths have been attacked. But I do believe that, and the reason why I believe this is because it came out of Trump's mouth. When he talked about the drug dealers back in like 2018, 2019 there, that he was going to shut down the drug dealers. And he specifically said, and I'm referring to the pharmaceutical industry. That's the drug dealers that he was talking about. He wasn't talking about cocaine and heroin and any of that, although that is, in essence, some of the pharmaceutical drugs. They do some of that stuff. They take some of that stuff and use it, but it's still turns into synthetic. Okay? It's not taken directly from nature and utilized as God intended us to use it. I know it's a tough one to overcome, isn't it, Leslie? I've had this conversation with some of my family members too, and for the most part, they've gotten most everybody off pharmaceutical drugs, the vaccines, all that good stuff. Yeah, I refuse pretty much to take any pharmaceutical drug. I mean, I still take Aleve once in a while for pain relief, but then I'm finding, Celtic salt, natural sea salt, is what we're actually, when we have like a headache and that kind of stuff, salt. Who'd have thunk something simple as salt? And this is my own experience. Now, I'm not giving medical advice here. I'm just repeating what I've heard from like some other people out there that know what the hell they're talking about. I was like, holy crap, so I went and got some. And I'll be darned if it doesn't frickin' work for me. Can't believe it. Yep, good old salt. And not your iodized table salt stuff. No. Celtic salt. Yeah. All right, so now we've had a little bit of fun there. I look forward to working with these men and other women on that military accountability project. And I keep seeing people raising their hand over here on Telegram. If you have some sort of a question or something, put it in the comment section. I don't take questions on a Monday Night Law. That's not what this is set up for. I don't let. I've learned my lesson with giving the floor to people I don't know, and it's not set up, and I don't know who you are, and those kinds of things. So if you have a question, put it in the comments, and whether I choose to read that and discuss that particular comment, I will. If not, I won't. Right? There's another truth bomb that our body needs cholesterol, and the way that they measure it is BS. It's all lies. I don't trust any of them, none of them, at all. I mean, once I got the fundamental understanding that pharmaceutical drugs is all synthetic and it's all fake, and the fact that there's no cure, they're not curing anything. And then the fundamental truth, which I have a plethora of evidence, technically speaking, I guess, a plethora of evidence, including my own public records request or FOIA request for proof of a so-called virus, and then all this other documentation from CDC, everybody worldwide, wherever you can think of, no such proof of any virus. Wait a minute. This is where we get into, oh, well, it's either a parasite or a bacterial infection. That's the truth. Those, a disease. It's a dis-ease, discomfort. Why? Because we're toxic. We're poisoning ourselves with the crap that we put in our mouths. Whether it's food or water or breathing it in. There's so many different ways to be exposed to toxins. The furniture you buy, the clothes you buy, the products you buy. Off gases and puts out all sorts of toxins. The food we eat, loaded with poisons. Whatever happened to the general welfare clause and regulating corporations and ensuring that commerce here, that they don't manufacture a product that may cause injury, loss, or harm to the people? Where are you at on that, Congress? I mean, what about the Food and Drug Administration? Why aren't you performing your fundamental principle, the intent, to ensure that nothing is in our food or drugs that may cause injury, loss, or harm to the people? I mean, that's the intent under the General Welfare Clause. That's who you're supposed to be regulating. Corporations, manufacturers of products. Not the people. Not man in the private. You're supposed to be defending the people and man in the private. That's the General Welfare Clause. Not to be construed as anything else. Here's another one for you folks. That new car smell, that's off-gassing of toxic chemicals. There was a recommendation out there that when you get a new car and that kind of stuff, air that sucker out before you even get into the car. Every time. And it may take years for that to completely off-gas. But even then, you leave your car all shut up and mostly heat, right? Sits in the sun and gets nice and warm. It really exacerbates the off-gassing. That's air it out before you get into your car. Excuse me. I knew that was coming. I felt it coming. I'm trying to hold it off. All right. So let's look into Blackstone. Let's get into this here. Thank you, Tiger. Diesel D's. New car manufacturers want to get you high with the new car smell, so you sign the contract. I know, right? Yeah, I've never had a new car myself, but I've been in a few. Okay. So let's get into Blackstone's Commentaries on the Law of England, where we left off last week. And this is the third absolute right. So the first absolute right was personal security. The second one was personal liberty. And now the third one, the third absolute right, inherent in every Englishman, is that of property. Thank you, Jax. Which consist in the free use, enjoyment, and disposal of all his acquisitions without any control or diminution, save only by the laws of the land. Notice that's not by statute. And let me tell you, Blackstone, at this particular point in time, he knew the difference between the law of the land and statutes. Now, what does he say here? Oh, well, the origin of private property is probably founded in nature. Probably. As will be more fully explained in the second book of the ensuing commentaries. So, we'll get there. As I'm digging through this, and I'm looking for, the truth about, at least at this particular point in time, about rights. And again, if the Supreme Court of the United States of America decided to cite Blackstone's Commentaries on the Law of England regarding the Second Amendment, which is that first absolute right, is exactly where they cited from. That's what brought me here to begin with. Okay? It most certainly is good for us to read from today, because that was just in June of 2022, pardon me. So yeah, June of 2022, the Supreme Court of the United States of America sought fit to cite what we're reading from right now. Again, don't you think we ought to be reading this? I do. Let's get back to have some of them a frequent reoccurrence to fundamental principles weekly here on Kirk's Law Corner. So that's what they cited there was from nature, is the right of self-defense. So this is what I've said before, is we have the right to acquire, possess, and utilize our property however we see fit. And that's essentially the same thing as free use, enjoyment, and disposal of all his acquisitions. Acquire. Whatever you've acquired. However you've acquired it. Whether you made it yourself, or you traded with your neighbor, or you bought it from your neighbor. But it's got to go by the laws of the land. But certainly the modifications under which we at present find it, the method of conserving it in the present owner and of translating it from man to man are entirely derived from society. And are some of these civil advantages in exchange for which every individual has resigned a part of his natural liberty? Now, that is in the English common law, not American common law. Because we made it where we all have the right to contract, and our right to contract is unlimited. See Hill versus Hinkle if you like your case law. No part of government has anything to do with interfering with our right to contract. There shall be no law, none, impairing the obligations of a contract. Our right to contract is unlimited. The only exception to that rule of law, maxim of law, is fraud. That's it. They really try to, in the English common law, because of the Roman civil law stuff, they really like to say that, well, we give up part of our natural rights when we enter into society. Nope. No. And even in this, Blackstone's Commentaries, he says, with the exception in America. But see, there again, that would be a fundamental error, a flaw. If it's an absolute right, how do you give it up when you enter into a society? That makes no sense. Then it's not absolute. I mean, where are we supposed to be? If we're not kind of essentially in society, where would we be? Think about that. The laws of England are therefore, in point of honor and justice, extremely watchful in ascertaining and protecting this right. Okay. Well, if they're protecting, as in defending, if it's a natural liberty, upon this principle, the Great Charter has declared that no free man shall be disseized or divested of his freehold or of his liberties or free customs, but by the judgment of his peers or by the law of the land. And that's right there at the beginning of section 139, right in the middle of that. So, how many times has this been stated in here that forgive me, folks, I need to take this. It may be important. Yes. What's happening? Yeah, I am. What's up? Okay. Bye. Possibly something going on outside. I don't know. I don't really hear anything, but again, I want to reiterate this, that how many times throughout here when we're talking about these rights and stuff, that they cannot be deprived without the judgment of our peers or by the law of the land. Never once does it say statute. Right? We need to fully comprehend this right here and speak that. Well, this right can't be, this is an absolute right, and this right cannot be deprived without the consent of a jury of my peers or by the law of the land? Can you point to the law of the land that says you have the authority to do what you just did or what you're attempting to do? Because if you can't cite the law of the land, then it's unlawful. It's not full of law. Your policy is not law. Enactments of the legislature are not law of the land. Despite what it even says there in misconstrued, most often misconstrued in Article 6, being the supreme law of the land, and anything made pursuant to, made pursuant to the Constitution, which is Article 5. Not statutes. Regulations, policy. And by a variety of ancient statutes, so to see, now he's talking about ancient statutes, it is enacted that no man's lands or goods shall be seized into the king's hands against the Great Charter and the law of the land. So that's ancient statutes prior to essentially the Magna Carta. But he even cites against the Great Charter and the law of the land. So essentially, we have law of the land here in America. England has the Great Charters. They have charters. And that no man shall be disinherited nor put out of his franchises or freehold unless he be duly brought to answer and be forejudged by course of law, so due process of law, law of the land, and if anything be done to the contrary, it shall be redressed and holden for none. And so the proper word out there, on YouTube, is land. So great, moreover, is the regard of the law for private property that it will not authorize the least violation of it. No, not even the general good of the whole community. If a new road, for instance, were to be made through the grounds of a private person, grounds, okay, there's another word, grounds, of a private person, it might perhaps be extensively beneficial to the public. But the law permits no man or set of men to do this without consent of the owner of the land. Yeah, so question out here is to tell the people out here the difference between a statute and code. Okay, code, as Blackstone lays out, and here's Roman civil law. Code. So every time you hear code, that's Roman civil law. Like United States Code, Uniform Commercial Code, Code of Federal Regulations, Idaho Code. Wait a minute. And like I've explained before in previous videos here, and rereading this, is it's a fundamental law. So this is what our founders put in the Declaration of Independence about altering our fundamental law and subjecting us to a jurisdiction foreign to our form of government, unacknowledged by our law, and subjecting the people to pretended acts of legislation. That's what's happened, folks. They've altered our fundamental law from the law of nations, the laws of nature, and the American common law back into Roman civil law again. This has happened over and over and over and over again throughout history, folks. And Blackstone lays it out in here. I've already covered that. Okay, the code was lost there in the Lombard invasion and was found in around 600 A.D. at Amalfi, or pardon me, 1130. It was lost at 600 A.D. around the Lombard invasion and was rediscovered in 1130 A.D. And then, even right here, that's where I pulled this from, was they called him Usurper Stephen, King Stephen, from 1135 to 1149. Or 1150. 59. That's why they called him Usurper Stephen, because he re-implemented the Roman civil law. And Blackstone even says, hey, that's a different, he compares Roman civil law to common law, to the English common law. Okay? So it's a completely different body of law, a jurisdiction, because that's jurisdiction. Juris being law, diction being words of that law. It's a body of law, which is why it is so important that we watch the words that we use. Diction puts us in that certain juris body of law, jurisdiction. So, in essence, we have to basically relearn vocabulary, proper diction. Okay? So, there's your revisiting the difference between a statute. Now, statutes and code. Statutes would be based off of certain subject matter jurisdiction, and who would that statute apply to? Only those that are bound by it in law. That's all in law. Now, so many people think that, statutes are the law. No, it is not. Not here in America, not in our republic, not our form of government. Our founders had enough of that. Right? Read the Declaration for the Causes and Necessity of Taking Up Arms. There it gives you a very clear indicator of why they wanted to get away from statutes as the law and said, no, we're separating ourselves from that admiralty jurisdiction, because essentially statutes are under admiralty jurisdiction. Can anybody point to any other jurisdiction that's in the Constitution besides admiralty and maritime? Article 3, Section 2. I have not found any other jurisdiction there. Some will say, original jurisdiction. Okay. What's original jurisdiction? Common law. Better read the Article the 7th of the Bill of Rights. It's not supposed to be heard in any courts of the United States except for pursuant on a review. Can otherwise be re-examined in any courts of the United States except pursuant to the rules of common law. So our common law courts are supposed to be separate from the courts of the United States. And when we're talking about review, those are writs from the common law. Writ of review, or now known as writ of certiorari, is a form of an appeal. Writ of prohibition, writ of mandamus, that's where a mandate comes from. Writ of habeas corpus. Imagine that. Let me just take a quick piece here. Okay, so now we know that those writs, writ of quoranto, there's another one, but I found that there's actually quite a bit of different writs out there. Yep. Yep. So back to Blackstone here. This is a fundamental principle. They will try to tell us, when talking about taking our land, our grounds, right? If a new road, for instance, were to be made through the grounds of a private person, it might perhaps be extensively beneficial to the public, but the law permits no man or set of men to do this without consent of the owner of the land. We talk about eminent domain. Well, eminent domain, if it comes in conflict with this, which one supersedes? I mean, is a road actually needed? Yeah, we want to put a road in here. We want to go right through your property. And it's funny, when they do this, they assess the value of what they're going to take from you a lot less than what you paid for it. See, but when you're wanting to buy it, it's way up here. But when they're wanting to buy it, it's way down here. All right. In vain may it be urged that the good of the individual ought to yield to that of the community. For it would be dangerous to allow any private man, or even any public tribunal, to be the judge of this common good and to decide whether it be expedient or no. Besides, the public good is in nothing more essentially interested than in the protection of every individual's private rights, as modeled by the municipal law. Now, when they say municipal law, that's the Roman civil law. In this and similar cases, the legislature alone can, and indeed frequently does, interpose and compel the individual to acquiesce. Now, I know that in my Idaho Constitution, again, I'm just going to go with that for a second. It does talk about they're only able to take public land under eminent domain, not private. They would still have to have your consent. But I mean, this would be where you have to use a little bit of logic and reason, right? If things are expanding and things are changing for the good of the community, yes, you might want to consider. But I've seen clear out in BFE no man's land, even outside of city limits, that they've pulled this eminent domain crap. Well, we're gonna do this, this, and this, and it's like, no. I'm not taking my land for whatever you want to do here. They were wanting to basically take farming land and start building business strip malls and that kind of stuff, and wanted to take the farmer's land, and he stood up for it and said no. Now, I've seen where some have shut it down and some were not able to. In this and similar cases, the legislature alone can, and indeed frequently does, interpose and compel the individual to acquiesce. But how does it interpose and compel? Not by absolutely stripping the subject of his property in an arbitrary manner, but by giving him a full indemnification and equivalent for the injury thereby sustained. That's supposed to be just compensation. The public is now considered as an individual, treating with an individual for an exchange. And that the legislature does, all that the legislature does is to oblige the owner to alienate his possessions for a reasonable price, and even this is an exertion of power which the legislature indulges with caution and which nothing but the legislature can perform. Now, notice that he's saying legislature. So many times these days, it's not the legislature that does it. It's these unelected bureaucrats in these executive agencies that are doing this. You know, like sometimes it's through planning and zoning. The city, the county. No, the legislature. The legislature is supposed to do this. But again, this is all part of the fundamental alteration of our form of government and basically stripping powers away from the legislative branch and putting it into the hands of the executive branch, which is part of one of the grievances from way back in the day about this is, you know, the separation between the legislature and the executive. Separating those powers. Because most of the executive branch are not elected officials. I mean, you got your governor, your lieutenant governor, you got your secretary of state, your treasurer. I guess down to county level, you have like county commissioners, you got your sheriff, city mayors. Oh, county prosecutor. Okay, there's another one. But most of everybody else is not elected. They're all unelected bureaucrats. So, back to the legislature for this stuff, right? Nor is this the only instance in which the law of the land has postponed even public necessity to the sacred and inviolable rights of private property. For no subject of England can be constrained to pay any aids or taxes, even for the defense of the realm or the support of government, but such as are imposed by his own consent or that of his representatives in Parliament. So this is where we get into taxation, right? And like, well, here, let me look. Let me check that. All right. Just checking some comments out there on Rumble. Thank y'all for tuning in out there. Okay. So again, if it's an inviolable right, inviolate, you cannot violate the right, except for essentially, again, by the consent, your own consent, or that of the legislature. Let's see, by the statute of 25 Edward the First, chapter 5 and 6, it is provided that the king shall not take any aids or tasks but by the common assent of the realm. And what that common assent is more fully explained by 34 Edward the First. Which, lots of good stuff there. Which enacts that no tillage or aid shall be taken without the assent of the archbishops, bishops, earls, barons, knights, burgesses, and other free men of the land. And again, by 14 Edward III, the prelates, earls, barons, and commons, citizens, burgesses, and merchants shall not be charged to make any aid, if it be not by the common assent of the great men and commons in Parliament. And as this fundamental law had been shamefully evaded under many succeeding princes by compulsive loans and benevolences extorted without a real and voluntary consent, it was made an article in the Petition of Right in 3 Charles I, that no man shall be compelled to yield any gift, loan, or benevolence, tax, or such like charge without common consent by an act of Parliament. And lastly, by the Statute 1 William and Mary, number 2, chapter 2, it is declared, or clause 2, it is declared that levying money for or to the use of the crown by pretense or prerogative without grant of Parliament, or for longer time or in other manner than the same as it shall be granted, is illegal. Which should be right around that English Bill of Rights of 1689. Because, like I said, folks, this isn't the first time that this crap has happened in history. So, I think this is getting into kind of like a summary here, so this is going to be some pretty good stuff in summary. In the 3 preceding articles, now what we're talking about here is Article 1, 2, and 3 there, about these 3 distinct absolute rights. The absolute right of personal security, personal liberty, and property. These are the 3 articles that we've covered here. So that's what this is referring to, these 3 absolute rights. Okay? We have taken a short view of the principal absolute rights which appertain to every Englishman. But in vain would these rights be declared, ascertained, and protected by the dead letter of the laws if the Constitution had provided no other method to secure their actual enjoyment. Excuse me. It has therefore established certain other auxiliary subordinate rights of the subject, which serve principally as outworks or barriers to protect and maintain inviolate the 3 great and primary rights of personal security, personal liberty, and private property. These are, now pay attention folks, because these are your source of limitations on these rights, or that are instituted to secure these rights. Okay, these are established. The Constitution, powers and privileges of Parliament, of which I shall treat at large in the ensuing chapter. Number 2, the limitation of the king's prerogative by bounds so certain and notorious that it is impossible he should either mistake or legally exceed them without the consent of the people. And this is regarding, a monarchy with the king. Even the king can't do it. Of this also I shall treat in this proper place. The former of these keeps the legislative power in due health and vigor, so as to make it improbable that laws should be enacted destructive of general liberty, improbable that laws should be enacted destructive of general liberty. The latter is a guard upon the executive power by restraining it from acting either beyond or in contradiction to the laws that are framed and established by the other. So we're actually talking about the Constitution. That's this thing, the Constitution. The law of the land. Bills of Rights. Because we're talking about established. Constitutions are ordained and established. Number 3, a third subordinate right of every Englishman is that of applying to the courts of justice for redress of injuries. Now, this is where we kind of get off kilter here about, well, what the heck is the court of justice? Is it really supposed to be the common law courts? Because that would where the justice of peace would be at. But it also talks about courts of justice are to be open without sale, denial, or delay. And then we're supposed to redress our grievances with the legislative branch. But and that's what I've read in my Idaho Bill of Rights Constitution type thing. So, I don't know. I really think it's actually supposed to be the courts of justice is supposed to be our common law courts. Because when it's talking about redress of injuries, injury, loss, or harm, and where we, the people, are supposed to have this common law power, our common law courts, that was a power retained by the people. Suits at common law. Suits in law, Article 3, Section 2, that's under Admiralty and Maritime. Suits at common law, not suits in law. But they've fundamentally altered our form of government. They stripped us of that power. But see, that's government de facto, and why we need to get back to government de jure. We need to reassemble government de jure, the common law side of our republican form of government. Bring back our courts of justice where we, the people, prosecute them. Where we prosecute our own claims. And get rid of this Roman civil law, and Roman civil law, the code, the form that infects the form of government as a fundamental law. It gives all the power to the king, to the parliament. Now, I think we need to abolish that again. It's that time. Since the law is in England, the supreme arbiter of every man's life, liberty, and property, courts of justice must at all times be open to the subject, and the law be duly administered therein. So that's it right there, that it is. It's the common law courts. And that would be the justice of the peace. Tiger, that's the thing. It's not just it's our right. It's a right and a duty to throw off such despotism and institute new guards for our security and safety. But the problem is the people don't have the knowledge. They have no education. They have no clue what our true Republican form of government looks like, nor what the powers of the people are, let alone how to exercise that, how to wield that power. That's our problem. I mean, I could lay out all the parts of an internal combustion engine, in boxes and all over the table and stuff, but if you have no knowledge of what those parts are, a book isn't even going to help you. Yeah, install the timing crankshaft gear and the camshaft gear, and then install the timing chain, and then install this. If you don't even know what those parts are, you don't even know what you're looking for. But again, you have to read the book. Now, I'll even admit, as a mechanic, still have to go to read the book once in a while. What's the torque specification? How's this done? And after I do it once or twice, I get it. I don't need the book anymore. Most of the time I remember that stuff. It's about frequency of use, though. But this is where we get that fundamental principle of the right to due process of law. You cannot deprive life, liberty, or property without due process of law, from the law of the land. Not from a statute, not from a code. Well, see, under Roman civil law, yeah. Because that's a different fundamental law. It's a different law. It's a different jurisdiction. It doesn't belong here in our republic. And see, and the law be duly administered therein. The law, rights as law. The emphatical words of Magna Carta, spoken in the person of the king, who in judgment of law, says Sir Edward Coke, is ever present, and repeating them in all his courts, are these. Nulla venem. Need to look those up. I wish I could highlight these and just do a quick search on it, but... And therefore every subject continues the same learned author. For injury done to him in bonus and terris vel persona by any other subject, be he ecclesiastical or temporal, without any exception, may take his remedy by the course of the law, and have justice and right for the injury done to him freely without sale, fully without any denial, and speedily without delay. That's without sale, denial, or delay. I mean, that's Magna Carta, 1215. It were endless, because they're talking about Magna Carta. That's chapter 40 of the Magna Carta. To no man will we sell, to no man will we deny or defer, delay, right, or justice. It were endless to enumerate all the affirmative acts of Parliament, wherein justice is directed to be done according to the law of the land. In other words, what that's saying is it doesn't matter what the legislature has to say about it. We go by the law of the land, not enactments of the legislature. And what that law is, every subject knows, or may know, if he pleases. Or may know if he pleases. It's up to us to learn this stuff, folks. For it depends not upon the arbitrary will of any judge, but is permanent, fixed, and unchangeable, unless by authority of Parliament. Well, see, we didn't grant that authority. That's actually in the law of nations. They do not have the authority to alter the fundamental law, period. Or the Constitution. That's Book 1, Chapter 3, Section 34. That question's been asked and answered. No authority to alter the fundamental law or the Constitution. Now, we did, the other part of that is unless it's expressly delegated, which it is under an Article 5 convention, or like kind in a state, to alter the law of the land. But it still has to be put to a vote of the people. You gotta have the consent of the people. But in my mind, there's only two ways to really do it. One is by the people themselves or by convention. This whole crap of, well, the legislature's going to propose this and we'll vote on it, we'll pass it, and then we'll send it off for at the next election for the people to vote on that. Then why even have the convention? See the problem there? Because I know there's people out there, well, it says right here that the legislature can do it. Okay. Then why even have convention? Makes no sense, does it? But again, how many times have we talked about this again tonight? Law of the land, by the law of the land. But according to the law of the land. Over and over and over again in here, folks, it's by the law of the land. And then this, Blackstone's talking about by second or 2 Edward III, clause 8 or chapter 8 and 11, blah, 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 that no commands or letters shall be sent under the great seal or the little seal, the signet or privy seal in disturbance of the law. This wouldn't apply to us in America, because that's not, we don't have that kind of form of government where they have that power, or to disturb or delay common right. And though such commandments should come, the judges shall not cease to do right, which is also made part of their oath by statute. Okay? But we made it part of the oath per supreme law of the land. That's Article 6, Clause 3. And then you got Article 6, Clause 2 that specifically states that the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary are notwithstanding. Period. There's a hierarchy here. Good question, Sharon. Jay Sharon, out here on Telegram. Am I saying that the Court of Justice is not the legislature as I've once thought? No, you're not misunderstanding. But I think it's supposed to be essentially one and the same now that I'm starting to discover that some of the older constitutions laid out how we would go to church with our grievances. Let's say church on Sunday, right? Let's just use this as an example. At the end of service, hey, has anybody got any grievances here? Yeah. Do we need to form a grand jury? Do we need to form a committee? This would go through the common law courts, the courts of justice. But I still think, in a sense, that part of the legislative branch is part of that first branch of government, the people, the common law side, which has to come first before the legislative branch is even created. Because the legislative branch is created by Constitution. So you have to have the common law side of our republic formed in order to create the Constitution itself. So the first initial branch of government is the people, where all of the political power is, which is policy, essentially. And even American jurisprudence talks about that. That 2017 update I got talks about how in, American Jurisprudence, Volume 16, Constitutional Law, Section 1 and 2. Section 2 talks about how statutes are for government civil conduct, but that the Constitution is actually but a higher form of statutory law because it's created by the people themselves. That's Section 1. It's absolute and unalterable, but by the people themselves. The power where it emanated from. So, I still hold the belief that the Court of Justice is done by the people. It's part of the common law. And we've, according to what our constitutions or bills of rights these days will read, there's the right to petition the legislature for the redress of grievances. So I guess it would just depend on what it's about. Karen out here on YouTube, no. How does one define whether political or law? I'd say judicial, but Kirk said judicial is legislature. No. Maybe I'm missing something here. No. Political arguments, not judicial. Yeah, that's when we're dealing with foreign invasion, but more specifically, this particular part here is dealing with internal insurrection, domestic violence, pursuant to Article 4, Section 4, is a political argument, not a judicial one. And if all political power is inherent in the people, shouldn't we be doing that in the Court of Justice, in the common law side, and we the people take care of business there? Because if all political power is inherent in the people, we would exercise that through our common law courts, which is, technically speaking, not part of the judicial branch under the Constitution. Again, this is the common law side of our republican form of government, which comes before the Constitution. When the Constitution, it delegates certain powers and certain jurisdictions, and that's it. Otherwise, we the people take care of that over here in the courts of justice, suits at common law, whether it's criminal in nature or civil in nature. Plain and simple. Let's get rid of this administrative crap. That's part of that Roman civil law, admiralty and vice admiralty jurisdiction, that the Declaration for the Causes and Necessity of Taking Up Arms, now that was July 6, 1775. That was one of the causes for taking up arms against them, was extending admiralty and vice admiralty jurisdiction onto the land. So instead of going by law of the land, they were going by administrative. Told you guys, this is not the first time that this has happened. Many times throughout history, it's the same old crap over and over and over again. This unwanted jurisdiction, body of law. No. And even as Blackstone is enumerating it here, okay? You can't disturb or delay a common right. But see, under Roman civil law, we don't have rights. We have privileges. Now, what do you think the 14th Amendment did? That's exactly what happened. That's part of that fundamental alteration of our form of government. back to subjecting us to pretended acts of legislation. It's all Roman civil law. It's all code, folks. Code, 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 code. It's not law of the land. It's not common law. It's not laws of nature. And there are no statutes when it comes to code. It's all just code. All of it. And in my mind, when you're looking at this, and it even says part of their oath by statute, when you talk about this, I'm almost thinking that's the Bill of Rights. It is declared that the pretended power of suspending or dispensing with laws or the execution of laws by regal authority without consent of Parliament is illegal. I mean, let's see if we can match that up. Let's see. Where are they saying that was? Was chapter 2, section 2? I'm almost willing to bet that's it. 2 and 2. Let's just look. Let's just look for shits and giggles. English Bill of Rights of 1689. 2 and 2. So the first part, that's all this here. Then you get into this second part. This is the second part. And thereupon they said, there it is, section 2, that the pretended power of dispensing with laws or the execution while regal authority has been assumed to exercise of late is illegal. So more than likely, yeah, that's right here. This is part of the statute they're talking about is this English Bill of Rights. These are the causes, and they're talking about that. By assuming and exercising the power of dispensing and with suspending the laws of execution laws without consent of Parliament, by committing and prosecuting divers where the prelates for humbly petitioning to be excused from concurring to the said assumed power. But yeah, that's right there. I'm willing to bet that's it. It's just not laid out as this being chapter 2, section 2. You kind of have to read between the lines on this, because that's the and the by, all which are utterly and directly contrary to the known laws and statutes and freedom of this realm. Then you get into this. This would be part 2. And sure enough, there it is, section 2. Clause 2, whatever you want to say. I mean, here we go. That the raising or keeping a standing army within the kingdom in time of peace, unless it be with consent of Parliament, is against law. Imagine that. Just saying. All right, so we're gonna call it a night here. We'll end right here because I know that this goes on for a little bit further here, but we're at looks like 142 and a half. All right. So, let's see. Just want to put this out here for those who would like to help support. Broadcasting live on all of these up here, upper left-hand corner, kirkslawcorner.com. Okay. Facebook, Telegram, YouTube, Rumble, and X. And then the P here is for Patreon. If you want to get on Patreon, help support over there, that's the way I do that right now. I don't have, PayPal or any of that anymore. They took me down a long time ago. So this is essentially the way I can take donations digitally, is through Patreon, tier 1, tier 2, $5, $10 a month, to help support what I do for free out here on Monday nights and anything else I put out there on any of the social media. Put out a lot of stuff on Telegram because it's there's no real limitation there on word count. I mean, there is. It'll break it up for you, but I can upload files and videos and all that good stuff there way easier than I can anywhere else. Other than that, if you'd like to get into Wednesday Night Workshop, that's tier 3. If you want one-on-one help, you got questions about whatever personal, whatever it is, that's, if you want one-on-one time with me, that's tier 4. Okay. And then I want to remind people the free educational series there on YouTube, which I've added some to the educational series. Now there's like 11 or 12 in there. And if you'd like to send anything over to the office, any postal money orders, regular money orders, cashier's checks, anything to help support, send that to me at 6477 West Fairview Avenue. Suite G now is in Gulf, Boise, Idaho 83704. All right. So I want to thank everybody for tuning in and wanting to be here to learn. Have a wonderful night, folks, and we will catch you Wednesday night. Those in Wednesday Night Workshop, we're working through my case file and explaining each document one by one. And once I get through that, I almost kind of want to break off of that and talk about some of the other things, but I want to complete that little series there. So, all right. So God bless everybody, and we will see you Wednesday Night Workshop for those in Wednesday Night Workshop. If not, Friday night, we'll see where I'm at this coming Friday. I'll put out a notice if I'm going to do it again or not, okay? And then if not, we'll see you next Monday.